everybody's all right. Nearly March, almost spring. Let's start with some positivity. So while everybody's logging in, I'll just talk you through a few bits that we sort of have on offer, as the title of the slide suggests, and then we'll get into the main bit of the session. We have a free employment contract review that we're running at the moment. We're still seeing a number of organisations that have employment contracts that aren't compliant, and that sounds a bit strange, but actually I think it was 2020 there was some changes in response to the Good Work Plan, which required employers to give new starters contracts that contained some new provisions, things around training and benefits and that kind of thing. And a number of people didn't clock it, partly because COVID got in the way, and we were all busy doing other things like furlough and the like. So we are doing a free review of contracts just to check whether they're compliant, and then we'll let you know what needs changing. We're also seeing a lot of training requests at the minute, where clients are wanting to upskill their managers in particular, or their HR teams. And we're running sessions on things like managing sickness absence, disciplinary grievances, investigations, equality, diversity, inclusion, that kind of thing. So they're pretty popular at the minute. So do let us know if that would be of interest for your team. If you're in the East Midlands, we also run something like something called the HR Network, the East Midlands HR Network, and that's a great way for HR professionals to get together, kind of share best practice and experience, and do a bit of networking, I suppose. And then about a year ago, we also released something called the HRD Talks podcast. We're on to season 2, and I was really pleased to chat with Vicky Walker at Westfield Health recently. That was the first episode in series 2. Again, I think Matt, who's making all the technical stuff work in the background, hopefully we'll be able to post a link to that. But if you search on your favorite podcast provider, the HRD Talks, it will come up on pretty much every platform, or ask your device in your home, your smart device, and it will play it for you. So hopefully, well, certainly the feedback we've had is that people are finding that really useful. So hopefully you will too. We've given a few minutes for people to log in, so we'll kick off. We're aiming to be about an hour to an hour and a half, and yeah, if you have any technical difficulties, we found that leaving the call and rejoining is probably the best option, a bit like turning your PC on and off, I suppose. But hopefully everybody's okay. There are lots and lots of familiar names, because I can't see too many faces, but lots of familiar names on the call, some new people, which is great. But I'm Nick Elliott, and I head our Employment and Dispute Resolution group. James is presenting with me today, and he'll introduce himself as well. He heads the employment team, and we are usually joined by Laura. So those of you that were hoping to hear from Laura today, she's been called away on a really urgent matter for a client who have a defence due on a tribunal claim today. So unfortunately, Laura won't be joining us, but James and I have stepped in and we'll cover her sections. There's another slide on the team, and those of you that are missing Laura won't get to see her picture there. But in terms of the plan for today, we're going to take you through quite a wide range of updates. There's actually a fair amount changing in employment law at the minute, or proposed to change in the near future. That hadn't been the case for a while, so we thought a general kind of overview on a variety of topics would be good. So hopefully there's something for everybody. If you have any questions, James and I will do our best to field those as we go if you pop them in the chat. And because there's 2 of us, usually that works pretty well. We will have a Q&A session at the end as well. And if you're brave and want to unmute and ask us a question direct, then we'd be really happy to try and do that. The other thing that we're doing, we've been running these webinars pretty much on a monthly basis. To be honest, we've covered most of the topics we think people would like to hear from us on. So it may be that we restart again and start talking about the same stuff, but we'd probably prefer not to do that. So if you would like to hear us cover a particular topic at some point in the future, we'd be really happy if you popped that into the chat as well, and we'll not necessarily guarantee that we'll cover it, but we'd like to make sure that we're covering, you know, what people are interested in and what people would find useful. So please feel free to fire those topics into the chat, and we'll see if we can cover those in the future. In terms of today, there's a fair amount on holiday pay. That seems to be the biggest change, designed, and James will talk about it in more detail, but designed to simplify holiday pay. I'm not entirely sure that's what it's done. Some of that is in force already, some of it is still to come, and James will grapple with the technicalities around that, and he's great on all that stuff. We're going to look at some of the changes coming very soon in April on flexible working. There's also been some stuff that's changed with discrimination, so James is going to take us through that. We'll look a bit of the kind of fire and rehire, the code of practice on that, and some TUPE stuff, and then there's a few bits and pieces on other topical kind of updates that we'll look at towards the end, including menopause, which again is pretty topical in the kind of HR world at the minute. So hopefully that's all okay, and I will hand over to James to start us off with holiday pay.
Thanks, Nick. Yes, good morning, everyone. Holiday pay, get it out of the way first. I think and for those that are a bit sleepy, they can warm into the webinar by the next topics. So holiday pay, we'll start off with a ridiculously long name for a piece of legislation. The Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023. You don't need to remember that, you'll be pleased to hear. And what that did was it amended the Working Time Regulations 1998 with effect from the 1st of January this year. Now, don't panic, because most of the changes are of little practical impact unless your holiday year starts. Well, it only works for holiday years that start on or after 1st of April 2024. So depending when your holiday year starts depends on when the changes practically impact you. If you start your holiday year on the 1st of January, then these new rules come into effect on the 1st of January 2025. So, changes partly linked to the EU law bonfire. Regular attendees will remember that we had a seminar about the EU law bonfire, and that was going to take effect at the end of last year. And it did for a lot of things. And there's an act called the EU Law Revocation and Reform Act. And I'm going to, rather than bore everyone with the sort of technical legal details of that and cut to how it actually impacts things. And essentially from the 1st of January this year, there's no longer a need for tribunals to interpret our legislation in line with EU case law. So what they did instead, in a somewhat hasty manner, was they amended our actual legislation to reflect what the EU case law actually said. So a kind of convoluted way of keeping things the same without actually keeping things the same. So a lot of these changes we're going to talk about now in the working time regulations are what could be described as baking in the impact of case law into the actual regulations themselves. And so is it simplifying things? Well, to a certain extent, it's making them slightly different to how they were in a way that's trying to replicate similarity. And in certain areas, there are things that are brand new. So we'll look at them in turn. So the biggest change in the new working time regulations, or the amended working time regulations, I should say, is they introduce a category of worker that wasn't previously subject to separate rules, and that's so-called irregular and part-year workers. And those categories of worker, and I'll come to what that means in a second, have a new system of holiday accrual. Now, the reason that was introduced in these regulations was to solve the so-called problem, and I think it probably is a problem, depending on whose point of view you take, that was created by the Brazel versus Harper Trust case. Now, that was a case of a music teacher who didn't work through the whole year. For example, she didn't work during school holidays, and she didn't necessarily work every week throughout the school year. But she was able to successfully argue that she was due 5.6 weeks of holiday at her full rate of pay for a week where she worked. And in the case, one of the points that was identified by the trust, Harper Trust, and the lawyers representing them was essentially saying, well, isn't this a bit silly? For someone who works the whole year, they get 5.6 weeks of holiday. She only works a fraction of the year. She gets 5.6 weeks of holiday. So in proportion, she gets more holiday. And the court's answer to that, to cut a long story short, was tough. That's what the law says. And so the new system, where there's a category of work called irregular and part-year workers, creates a position that those lawyers in that case were suggesting would be fairer, where in essence, holidays accruing in proportion to the amount of work that someone is doing. We'll look at that in a bit more detail. So what is an irregular hours or part-year worker? An irregular hours worker is defined as somebody whose hours are irregular, and that means they're either wholly or mostly variable. So classic examples would be a casual worker who might pick up shifts one week and might not the next, or they might pick up lots of shifts one week and not many the next, but they've got no guarantee of any number of hours. So someone on a 0 hours contract. Agency workers would be another classic example. There's some guidance been published, and a good sort of example of someone who isn't an irregular and part-year hours worker would be someone who worked on a rotating shift pattern where they did 20 hours one week, 10 hours the next, 20 hours one week, 10 hours the next. Because although they don't work the same number of hours each week, their hours aren't irregular. Their contract defines what they are. So it's not the same as the old definition of someone with no normal working hours, but somebody with no normal working hours is likely to be an irregular or part-year worker. So I've covered irregular workers, that discussion about no fixed hours or hours that are wholly or mostly variable. A part-year worker is someone who for at least 1 week per year doesn't work and are not paid in that week. So if you have a term time job where you're paid weekly and you don't get paid during the summer, unless you're on holiday, then you would be a part-year worker. If you were paid for the whole year but only work parts of the year, then you wouldn't be a part-year worker. So that distinction is important because you can only access this new holiday pay regime if you fit into that definition. And as I said in the introduction, that this new rule and category of worker is only relevant for leave years starting on or after 1st of April 2024. So nobody can yet be doing this under these rules, or at least if they are, they don't yet apply. So it would be a strange thing to do. Next slide is about accrual. I mentioned that sort of the premise of the new rule was so that holiday is accruing in proportion to the amount of work that's actually being done. The interesting practical quirk of this is the regulations say that the holiday accrues on the last day of each pay period. So if in the first month you would have no holiday at all if you were paid monthly until the last day of the month, and then you would accrue a month's worth of holiday under this calculation. If it was weekly, it would be the end of the week. Now, a lot of commentators immediately latched on this, and you might have already thought of this problem. Well, what happens in the last week of the year when it's seemingly impossible to take your holiday because you don't have it? Then it accrues, and then in theory, the last day of the year, then move into the next year, and you're in the new year. And what does that happen then? Does it carry over? The answer to this is I don't know. I imagine that people will be slightly more pragmatic than this suggests. But that's something that would be interesting to see how that's ironed out, or whether they amend it, or how it's interpreted when it's actually in force. The rate of accrual, some of you may be familiar with this so-called magic percentage, the 12.07%. It featured in a different context in some now long archived ACAS guidance that was swiftly taken down when Brazel v Harper Trust said that essentially using it is wrong, or is liable to get you to the wrong answer. It's now relevant again, but in the actual regulations and in a slightly different context. So the point I was making about holiday for these irregular and part-year workers accruing in proportion to work done the accrual rate is 12.07% of hours worked. So if in the month, and I'm going to see if I can do maths in my head, well, I should be able to. If in the month the person did 100 hours, then they would accrue 12 and a tiny bit of change of hours holiday. I think the rounding system in the regulations would mean you'd round that down to 12, but I'm not intending for the purposes of this webinar to go into the details of the maths of the calculations or the various complexities of the rounding, but you get the general gist that if you did 100 hours, you'd get approximately 12 hours holiday. Whereas if you did 200 hours, you'd get 24. And it's seen as a sort of fairer, more logical system. For anyone who's scratching their head saying, where's this 12.07% come from? For the mathematicians out there, it's a fraction. So the law says, as you're probably all familiar, you get 5.6 weeks holiday per year. There's 52 weeks, give or take, in a year. If you deduct your holiday from the 52, you get 46.4 weeks. So your ratio of holiday to working is 5.6 to 46.4. If you divide those two numbers together, times it by 100, you get a fraction that comes to 12.07% rounded to 2 decimal places. So if anyone wondered, you don't need to know that, but just in case you wondered. Sick leave, you'll probably all be familiar with holiday accruing during sick leave under the current regime. That's been baked into this new regime. And that's also worked out on an average. So if you're off sick and you can't work, you still accrue holiday. And that's another calculation. It's the average over a 52-week reference period of the hours worked. And that would also apply for other forms of statutory leave, maternity leave. So again, somebody on maternity leave who's an irregular and part-year hours worker will, under this regime, still accrue holiday as they would under the old regime. And then this will seem slightly contradictory. If you've read up on these rules, you might be thinking, well, I thought it was the opposite to this. Well, it is and it isn't. That's the beauty of these changes to working time regulations and how I think it's wishful thinking to suggest this makes it simpler, is that at least for the purposes of irregular and part-year workers only, there is a single unified holiday entitlement per year. So as I say, it accrues at the rate of 12.07%. And that's all based on the premise of workers having the right to 5.6 weeks per year. So under this regime, the distinction between the so-called first 4 weeks of holiday, which is the regulation 13 leave, and the second 1.6 weeks holiday, the so-called regulation 13A leave, that disappears because this irregular and part-time, sorry, not part-time, irregular and part-year worker leave derives from a different part of the regulations that didn't previously exist. So the distinction between the 13 and the 13A leave, the 4 weeks, the 1.6 weeks, does still exist, but not in the context of the new rules on irregular and part-time workers. So just to complete the jigsaw of irregular and part-time workers, so they've now accrued holiday at the rate of their 0.07% of hours worked. What do we pay them, or how do we pay them for that holiday? Under the old system, there was only one, at least lawful option, and that was the same as essentially the first option under this new regime. And I've described that as the orthodox way or the normal way, where someone would go on holiday in a pay period and then they'd get paid in the normal way at the end of the month, the end of the week, whenever the pay period is. You can still do that, you'll be probably pleased to hear, for irregular and part-year workers. And the rate of holiday pay is unchanged to a certain extent in that it's still a week's pay for a week's leave. A lot of the law on a week's pay was very complicated, and under the old law it was derived in different bits of legislation. The changes to the working time regulations has for the first time introduced a definition of a week's pay within the working time regulations itself, and we'll come to that on a later slide. The other way you can pay, so other than just paying it when they take their leave, is so-called rolled up holiday pay, which some of you may have heard the term, be familiar with, may even have done it because there were ways you could have gone about it under the old regime that, whilst technically not allowed, wasn't hugely risky and had certain advantages. So what is rolled up holiday pay? Rolled up holiday pay is where, instead of paying when someone is on leave, you just pay them more for the hours they actually do work. And that amount more is, you'll see the number again, it comes up again, 12.07% more than they would have got. So if their hourly rate is £100 an hour, you can see I'm good at maths, so I keep using 100 as the percentage. Then if you're doing rolled up holiday pay, you just do £112 an hour and 7 pence. And then the quid pro quo for that is when they're not working and are so-called on holiday, you pay them nothing. And the reason that was previously unlawful was a concern that what would actually happen is that people would be delighted to be earning more when they were working, and they just wouldn't take their holiday, and it would disincentivize people from taking holiday. And that went against the premise of the European directive and annual leave as a concept. Under the working time regulations now, and for leave years from 1st of April, you can now lawfully do this, but the regs do build in some safeguards. So one of them is the point I've highlighted at the end of point 2, that employers using this option must allow their workers to take holiday. So you really need to be being absolutely clear that people have to take time off where they're not paid, because I imagine there'll be case law down the years where there's a debate as to what that entails, and whether or not people are pulled up, employers are pulled up for sort of creating a bit of a pretense that people can take holiday whilst allowing them to work the whole year and get their rolled up holiday pay just to increase their earnings. The next side, holiday pay calculations. I mentioned earlier about definition of a week's pay. This is where it is. The working time regulations are so messy now with all these additions. You get brilliant subsections like 3ZA. You can get them all on legislation.gov.uk if you ever did want to look at them. I did for the purpose of this webinar, so hopefully that'll save some of you the trouble. But what section 3ZA does is it bakes in a lot of the case law that you might have heard me and other people talk about in previous webinars on the topic, as what you need to calculate, how you need to calculate a week's pay for the purposes of holiday pay. And this puts 3 bullet points, which aren't that easy to understand. But the first one is that a week's pay needs to include payments, including commission, intrinsically linked to the performance of tasks the worker is contractually obliged to carry out. So that's
Looks like we may have lost James on the basis that he appears to be frozen on my screen. So we'll just give him 1 second to come back. This is the beauty of online webinar. What I'm certainly not going to do is step in and steal his thunder on any of this. Oh, we might have him back. So James, you're moving on my screen, but I can't hear you.
Can you hear me, Nick?
Yes, got you now.
So I had a bit of a power outage on my laptop. Sorry about that. Did you step into the breach, Nick, or did
Of course
you
I
just
didn't.
hope that I was
No,
going
absolutely
to?
not. There's no way that I'm touching any of this, James. I'm very, very happy for you to continue.
I didn't want to repeat what you may have said.
Hopefully we're all still with James. We'll get there. We'll get there. Stick with us.
Apologies, Matt. We're nearly done on holiday pay. You may or may not be pleased to hear. So the first payments include commission intrinsically linked to the performance of task workers contractually obliged. So that would factor in for those of you who remember these cases, British Gas and Lock, where the people were getting mostly paid by commission with a low base, but their work meant they almost inevitably earn commission. So that bakes that type of thing in. The second, payments for professional status or service related to length of service. So again, payments that people are getting as a matter of course, just for carrying out their job. And the third one, the thorny one that causes all the problems overtime. So payments such as overtime payments, which have been regularly paid to a worker in the 52 weeks preceding the calculation date. So all those problems we always used to talk about whether overtime is worked sufficiently regularly to be normal, that is still a problem in that overtime still needs to be factored into holiday pay if it's regularly paid. And all the old case law about what's sufficiently regular to be normal will be relevant to interpreting this regulation 3ZA, because the point of 3ZA is effectively to write into the law what the case is said. But the two-tiered system for this still exists. So this definition of a week's pay applies for leave taken under Regulation 13, but not Regulation 13A. So you still have the odd situation where regularly paid overtime needs to be factored into the first 4 weeks of holiday, but not the next 1.6, and potentially, depending on the terms of the contract, any more holiday that you offer over and above the statutory minimum. So it's the same mess in a different form, essentially. And the reason that the government have given for not fixing this is along the lines of they didn't want too radical a change. But I think the real reason is it'd be really tricky to fix it. And because of the reform of all the laws coming in on the 1st of January, they needed to do something. And so this is a short-term fudge. And we might see further changes where there is a unified holiday regime in the future. There's sort of a hint that they might do that, but as of now, it doesn't exist and it's not in the amended regs. And finally, carryover. So most of you will remember, I suspect, the original position in the Working Time Regulations 98, which was essentially that you can't carry over holiday from one year to the next. And then there was a load of cases that came along that firstly said you could carry over it in the event of sickness, absence, and other situations such as maternity leave. And then there were some special rules brought in for COVID, which talked about when you could carry over, where people were prevented of taking holiday because of COVID. Luckily, the COVID rules have gone, so we can ignore those. And I say that luckily, I mean, because largely COVID is gone in terms of the law anyway. So there is now new rules about carryover, and they're on the slide, which again seem to be attempting to bake in what all the case law said that you had to read into the regs, which said you couldn't carry over holiday, when in lots of situations you actually could. So in some ways that's good, because people looking at the regs are going to get the right answer, not an answer that's not quite the full picture because it doesn't factor in the case law. So when can you carry over holiday? Where someone's unable to take it due to a period of statutory leave, so maternity leave, for example, where they're unable to take it as a result of a period of sick leave. That's caveated with the carryover must be taken within 18 months of the leave year to which it relates. That's just codifying what came up in a European case. Many of you might have seen clauses in contracts to that effect, that it'll only carry over for 18 months. I know I add it in just because it's a good thing to do in terms of your contracts, in again preventing anyone from getting the wrong end of the stick. And certainly before this law existed, it wasn't widely known that the European law had said that's the sort of stop gap for how long you can keep carrying it over when it's not taken due to sickness. And then in the third one, and I think this is a sort of anti-avoidance worker protection reason, it's where in any leave year the employer either fails to recognise a worker's right to holiday or paid holiday, which hopefully not many people are doing, but could happen if you had a dispute over whether someone was or wasn't a worker, for example, or they don't give the worker reasonable opportunity to take their leave or encourage them to do so, or inform the worker that holiday not taken by the end of that year will be lost. And just to keep the things nice and complicated, the second two bullet points only relate to the carryover of the first 4 weeks of leave. The first bullet point relates to the whole 5.6. Why, you may ask? I'm not entirely sure. Must be something from the European case law, but it seems slightly illogical distinction. And the only practical thing I might want to say on the third bullet point is when you're in your new era holiday year, so if yours starts on the 1st of April 2024, or the next one after that, is if you do operate a carryover rule as per the third bullet point. You might want to be having some kind of posting on your internal intranets or email circulars, essentially saying to everyone, our rules on holiday carryover are X. If you don't take your holiday in the relevant year, either you'll lose it or you'll only be allowed to carry over Y. We do encourage you all to take it, so that you can't then be criticised for not giving people reasonable opportunity and or informing them that if they don't take it, it will be lost. So it might just be a sort of a matter of course, good practice point to start doing. And there's no reason to not do it anyway, because people should be taking their holiday. It's generally a good thing, and making people aware is worth doing. So the good news is that's the worst bit of the webinar over for complexity, and I'm going to hand over to Nick to something a lot more interesting, flexible working.
Thanks, James. Well done for getting through that. You actually had people join the call. I was expecting people to drop off the call during that, but everybody seemed to make it through, and people even joined us. So well done, James. Joking aside, it won't surprise you to hear that James in particular is quite busy helping clients get this right, because it's very complicated and confusing. So if you do need any help with it, obviously do get in touch. Something a little bit easier for the next section, and probably a bit more familiar on the basis that it's coming in pretty soon. So flexible working requests, quick reminder of the existing law as it stands. So employee has to have 26 weeks continuous employment with the employer to make a request. And again, most people will be familiar with the kind of request that people might make, anything to do with their working arrangements, essentially, so their hours or where they work from, that kind of thing. At the minute, one request can be made in the 12-month period. Employer has 3 months to consider that, and then has to notify the employee of the decision. And everyone's favorite, the 8 reasons that you can give as the employer for refusing a request, and they're set out in the law. And it's things like it would cost too much, it's too disruptive to the business, we don't need you to work at those times because there's nothing for you to do. You know, for example, if you're in retail and you've got a request for someone to work after 5 o'clock and the stores are shut, or that kind of thing, you could legitimately rely on that ground. So that was the position. This has been talked about for quite a while in terms of the changes that are coming. And in fact, a number of big employers have already made the changes that are to follow. And those are that an employee can make a request for flexible working from day one, from the point at which they join you. They don't have to any longer explain how they see the effect of their request would impact on the employer. That was part of the previous regime. So actually they can just make the request, and it's for the employer to work that bit out for themselves, which of course in many cases was the way that it worked anyway. Not only is it a day one right, but there's actually increased the number of requests that can be made within that 12-month period, so they can now make 2 applications for flexible working. But they can't make a second request if they've already made an application that's already being considered, which again makes sense. But as you can see, within the 12-month period, that's potentially a couple of requests. It is quite a bit of work for an employer to consider. And as part of that consideration, the employer now has 2 months to consider that request and go back. And again, most employers should be capable of doing that. The employer is not able to refuse the request unless the employee has been consulted, and that we'll look at what that means in a bit more detail. And again, generally speaking, that was something that employers were doing on requests previously anyway, but it's kind of written into the new legislation. And of course, there's a few things that haven't changed. So employee still triggers the process, the statutory process, by making a request in writing. So you may well decide that if an employee hasn't done that, you want them to put it in writing to you as the employer. Employer has to deal with it in a reasonable manner, and those business reasons for refusal still apply in terms of rejecting the request if that's what you decide to do. One query that often comes up when we're helping clients manage these kind of requests is, do I need to give the right to appeal? So if the employee isn't happy that their request has been rejected, they might well decide that they want, to complain further about that. And although they're not obligated, or you're not obligated as the employer to do that, it is recommended in the ACAS Code of Practice. And I guess in terms of good employee relations, it might well be worth following that process and letting someone else consider it if the employee is particularly unhappy. In terms of the risks involved with these requests, James and I were talking about this earlier this week. We haven't seen many standalone claims for breaches of the statutory procedure. They tend to be tagged on to other claims. So if someone's been dismissed or resigned and is claiming constructive dismissal, or there's a discrimination claim, particularly sex discrimination claims, this might be a claim that is also brought, and the tribunal can award up to 8 weeks pay for a failure to deal with this properly, essentially. So it's not a huge risk, but obviously in the mix with other claims, it can cause an increase to any kind of compensation that you might face if the employer were successful. I talked about a new requirement to consult with the employee. In my experience, most of the time, employers were talking to the employee about their request and why they were making it, and any difficulties that either party might face in accommodating it. But there is a bit more detail on this, where the employer should invite the employee to a meeting. It should be held without unreasonable delay. It should give both parties time to prepare. There should be a reasonable discussion and consideration of the request, and I guess that might well involve the employer providing information as to how things might work or not work as part of that arrangement that's being requested. And also, I think interestingly, and again this happened on many occasions, I think, was the obligation to discuss potential modifications or alternative options. And I think most employers who were open to being flexible and accommodating employees would probably have done this anyway. But again, it's there as in sort of black and white, because it may be that a compromise can be reached to accommodate the flexibility that the employee is looking for, but also meet the needs of the employer. And again, often people kept written records of those meetings, so there's an audit trail. We would recommend that in pretty much every circumstance. But again, it's specified there as a kind of a requirement or best practice. So that's, as I say, probably the update that's coming next, in terms of it being 6th of April. And James is going to talk to us a bit about discrimination in the Equality Act.
Yeah, thanks, Nick. So just a short section on changes to the Equality Act. There's some amendment regulations for that, which do the same thing as I was referencing in context of holiday pay. Essentially, the law was changed as of 1st of January to bake in the impact of some EU case law on the basis that the regulations, or the Act in this case, Equality Act, doesn't need to be read to be consistent with the EU case law anymore. So in order to make it consistent as of 1st of January, they've made some changes. And one of them is in relation to indirect discrimination claims, as what is effectively a new category where an individual can bring an indirect discrimination claim if they have been put or would be put at the substantively same disadvantage as the group who have the relevant protected characteristic. Now, if you're thinking, what on earth does that mean? You're how I was when I started reading these cases a few weeks ago. So hopefully when we get to the end of this section, that will make some sense. But the critical thing is the last bullet point, where they do not share the particular protected characteristic. So it's a widening of protection in a slightly odd context, which I'll come to shortly. So this is what the law actually says. It's a new section, and it looks very similar to a standard indirect discrimination claim, but just with the one key aspect sort of flipped around. So as with any indirect discrimination claim, somebody, usually the employer, applies a PCP. That's a provision, criterion, or practice, a rule or policy, something that applies to everyone. In a classic indirect discrimination claim, you've got a person with a characteristic, a protected characteristic, and they suffer a particular disadvantage, and so do other people who share that characteristic with them. This claim covers that scenario, but not in respect of the person or the people with the protected characteristic, but somebody else who put to the same disadvantage substantively, but doesn't actually have the characteristic. And as with all indirect discrimination claims, the person applying the PCP can defeat the claim if they can justify it as justify the application of the PCP as a proportionate means of a legitimate aim. So the only new bit is essentially that the person bringing the claim need not have the relevant characteristic. A lot of people have called this associative indirect discrimination, but I found that hugely confusing because normally a discrimination by association claim is you say, as the person bringing the claim, well, I'm associated to X person who has this characteristic and I've suffered discrimination. And that makes sense. The word association is being used in its normal context. Here, there doesn't really need to be any association at all. You're simply saying that that group of people are being put at a disadvantage because of their characteristic, and I am suffering the same disadvantage. You don't need to be associated with them in any way at all. Right, so for those of you that are still wondering what on earth I'm going on about, here's an example that hopefully will make sense. Employer has a PCP that its meter readers must be at least 6 feet tall. Now, I made this up, but let's assume for the purposes of my meters that they're really high, just above maybe 6 feet. So you can't read them unless you're tall. And I make this blanket rule. You probably all think it's a silly rule, but go with it for purposes of this webinar. And a 5'10" man brings a claim for indirect sex discrimination because they think my rule puts women at a particular disadvantage because statistically women are much less likely to meet the criteria than men, because I tried to find something fairly uncontroversial, which is that men are generally taller than women. I think we'd all agree on that. So previously, this claim would only work for women to bring. They would say this rule puts women at a disadvantage. It's not justified. Indirect sex discrimination. They can still do that. That still works. But now, what you couldn't do before, under the regulations at least, or under the Act, is a man can now bring that claim and say, I'm put at a disadvantage by this sexist rule, and it works just the same. The reason this was baked into the legislation, so to speak, is because there were some European cases where someone who didn't have a characteristic sought to argue that they'd suffered discrimination, and that claim worked. And some commentators have suggested that they're not convinced that that would have actually made its way into mainstream legislation, but it has now. So that's the law as of 1st of April. So indirect discrimination claims can be brought by people who don't have the characteristic of the group that's put at a disadvantage. Whether or not this will actually lead to a lot more claims, I'm not entirely sure. But one analysis I've read that I suppose people might generally agree with, and I thought it was quite a sensible analysis, which is that all this is doing is making discriminatory rules unlawful. It's just more people can seek to bring claims about discriminatory rules, not just the people who are in the groups affected, anybody else who's adversely affected, even if their group isn't. So in this case, a shorter man. The context I think it could be used more widely is in the sort of sex discrimination example, where the courts and tribunals have recognized over the years that there is a childcare disparity burden on women. So when women are saying, I needed this flexible working request of going an hour earlier on a Wednesday because I needed to pick up the children, the courts don't delve into the evidence of whether women as a group suffer a disadvantage for the childcare disparity burden, because it's accepted that they do. Men can now latch onto that and say, you're not allowing flexible working, it's putting women at a disadvantage, and me in this case, because I suffer the same childcare disparity burden, because in my family I have the childcare disparity. So that would be another context where I could see it actually coming up. So that's one to be aware of. Back to Nick.
Thanks, James. So we're now going to look at the new code of practice on dismissal and re-engagement, or fire and rehire. So this was mainly in response to the furore that there was as a result of the P&O situation. So you might remember a little while ago now, P&O basically fired a whole load of people. They didn't do it very well. I think it was a Zoom call announcing that they were all being dismissed. And in that situation, they were all being replaced by cheaper foreign workers. So it wasn't quite fire and rehire the same people. It was fire and rehire different people. But it got a lot of press attention. It got a lot of attention in Parliament, and everybody got very upset about it and very excited about the fact that we should do something to prevent that kind of thing happening. Of course, there were things in place already that gave people remedies in those kind of situations, unfair dismissal and discrimination claims and that kind of thing. And there was also case law around the area of dismissal and re-engagement, or fire and rehire. But what this code of practice is designed to do is to help employers do this properly, do it well, and it provides guidance essentially for employers who are considering making changes to employees' terms and conditions, and in particular where if those changes aren't agreed, employers might decide to dismiss those employees and then usually offer them new terms, making the change that they're seeking to agree. So that's what this is generally about. A breach of the code doesn't result in a sort of standalone claim for the employees, but a bit like breaches of the ACAS codes on disciplinaries or grievances, it can feature as part of the tribunal's considerations when they're awarding compensation, and they can uplift up to 25% for breaches of the code. I should say we're expecting this to come into force in the summer of this year, so that's still a bit uncertain. But as I say, lots of these principles already apply and are kind of best practice and the law, in inverted commas, already, because of the case law that's developed over time in this area. But we'll look at some of what the code is talking about. So consultation is a key feature. And again, that would have been the case anyway. But essentially what the code is saying is you need to talk to your employees about the fact that you want to change their terms and conditions. It doesn't sound particularly revolutionary because we're seeking to get their agreement on that. But it does give some guidance as to how that should work. It should be as long as reasonably possible and in good faith and with a view to reaching an agreed outcome. So essentially designed to be genuine and not just a sham or, going through the motions from the point of view of the employer. As much information as possible about the changes should be provided, and as early as possible in that consultation process. And the employer should be clear about what the objectives are and what the nature of the proposal are, so that the employees understand what's being proposed. And again, if we were helping a client with this, we'd be saying, look, actually, you need to be really clear as to what your business case is for making these changes, why you need to make them, provide that information to the employees at the beginning of the process so they understand what's happening and why and what the change is and that kind of thing. The code also suggests that you should be open as the employer to genuinely considering any reasonable alternatives, and again, that would be good practice anyway. There's a slightly strange section where the code suggests that you should contact the ACAS. You should contact ACAS for advice before raising the prospect of dismissal and re-engagement. And we're not entirely clear yet what that means, as in whether that's because you should be looking to help you get ACAS to help you with resolving any disagreements, or you should be seeking advice from ACAS, or we're not entirely sure. And certainly a bit strange if you've got professional legal advice, supporting the process anyway. So we'll see, what further information we can get on that front. And again, the code is pretty clear. In fact, the main gist of it appears to be that dismissal and re-engagement as part of this consultation process should be a last resort. And as some of the slides to come suggest, it shouldn't be raised on what the code describes as unreasonably early, and it shouldn't be used as a threat. And James and I have been debating this because we kind of get the gist of that, and that it's designed to avoid employers sort of browbeating their employees into agreeing changes that are unreasonable, or that they don't want to agree, or that kind of thing. But at the same time, it seems to us that being open about the fact that the process may result in you deciding that because of the business case that you have for making these changes and the need that you have for making these changes as the employer, that one outcome of the consultation process might well be that you decide to dismiss and offer re-engagement. So that will be interesting to see how that develops in terms of when is the right time to to be open about that. And I think it probably is partly going to be the manner in which it's raised, and if it's clear that an employer's basically said, agree this or we're going to sack you, and done that in a way that's not appropriate, then that might not be okay. Whereas if effectively you're saying, look, we're really keen to agree these changes, this is why we think it's necessary, and as a worst case scenario, if we can't agree a way forward, it may be necessary for us to consider dismissal and re-engagement. It may be that the way that it's presented is helpful, but we'll see how that area develops. Yeah, so that's kind of a whistle-stop tour. I would suggest reading the code if it's an area that that you're likely to be looking at. I think even though it's not in force until the summer, we think it does give some guidance as to the best process to follow, because like some of the other stuff that James talked about, it's effectively codifying the position already, and it is useful to take a look at what would be expected in that process in any event. So it's a good starting point. James, TUPE.
TUPE, yes. Now this is probably one of the more straightforward and widely seen as positive changes that we're talking about today. So that's hopefully good news. So that dreadfully titled piece of regulations also amend good old-fashioned TUPE 2006 as of the 1st of Jan this year. And I think this time it does simplify the law, so that's good. So what's changing? There's only one thing really, the duty to inform and consult. And no panic on this one because it only applies for relevant transfers taking place on or after 1st of July this year. And that's that employers will be able to inform and consult directly with employees if either the employer employs fewer than 50 employees, and that's the employer who has the duty to inform or consult. So the employer of the employees who are affected by the transfer, and that's 50 in total, or if there are fewer than 10 transferring employees, and this ability to inform and consult directly with the employees only applies where there are no appropriate representatives. So by that, a recognised trade union or elected employee representatives for the purposes of informing and consulting under TUPE, and if the employer hasn't already invited the affected employees to elect employee representatives. So you essentially, that's just saying you can't bypass the trade union that's recognised or elected reps, or if you elect your own reps and then you don't like them because they're awkward or whatever, you can't then bypass them. But if at the beginning there are no reps, then you don't need to appoint them if you don't want to, and you've got fewer than 50 employees in total. The current micro employer definition that still applies up until transfers taking place on or after 1st of July 2024, is fewer than 10 employees. So it's really just tiny businesses. So it almost never applies. It was one of those ones where it came in and everyone thought it was great. But I think I've advised on 1 or 2 where people actually had few enough employees for it to count. And the common misconception was that it was fewer than 10 transferring employees, which it never was. It's always in relation to how many employees the employee has in total. So you might only have one person going across, but if you've got 11 employees or 10 employees, you would need to elect employee representatives, or at least the duty was there to do that and facilitate it. The one sort of slightly quirky thing about this is it brings in this new category of transferring employees. Under the current law, and still in the law, even post 1st July 2024, your duty is to inform and consult with affected employees. So someone who's an affected employee could be someone who is due to transfer, or it could be someone whose job is likely to change because other people are transferring, because clearly there's often a knock-on effect. So you top them up for the purposes of who you need to consult with, affected people. So you could have a slightly odd situation where you've got 10 transferring employees, but you're consulting with 15 people because 5 of them aren't transferring. And I can see people could get into a bit of a tangle about that. But there we are. The limits of when you can consult directly is where there are fewer than 10 transferring employees. And given that where the group of employees transferring are low, it's often impractical or irritating to have to go through an election process where there's no trade union. So I think this is a positive change, and to a certain extent sort of legalizes what many people have been doing anyway in a roundabout way. So I think that's a good thing, and it should make TUPE transfers easier for both employer and employee, whereas not many people transferring. So that's pleasingly, in some respects, the only change to TUPE that you need to worry about. And back to Nick.
Thanks, James. So on to a few other updates. Is that moving the slides, James? Yeah. So we should have menopause. So Equality and Human Rights Commission really very recently, as in this month, released some guidance for employers on menopause in the workplace. And that's aimed at helping employers understand their legal obligations. And it provides lots of detail on that. It makes recommendations about things like workplace adjustments, so changes to the physical work environment, promoting flexibility, recording menopause-related absence separately from other absence to try and avoid discrimination risks, that kind of thing, and also encourages an open culture so that people can talk about the menopause and symptoms and any workplace adjustments that might be necessary. We've certainly seen an increase in both clients asking for advice in this area, and also we've seen an increase in tribunal claims in this area too. So I think definitely worth having a look at that guidance. Obviously, if we can pop a link to it in the chat, either John or James or Matt, that would be great. But also, one of the issues that is kind of being debated and grappled with by the tribunals, or debated by commentators, I think, is whether actually menopause should be protected within discrimination law, within the Equality Act, as something standalone itself, or as it has been covered thus far, whether disability discrimination protection is the right way to be considering that. And there are certainly plenty of people saying, look, it should be a standalone thing. It's not a disability, as people commonly, would refer to it. But certainly so far, the way that the tribunals have approached it is to kind of shoehorn it into one of the other types of discrimination, very often disability, but of course age and sex discrimination are also relevant and often claims that are brought as well by anyone who's bringing that kind of claim against their employer. So we just thought we would quickly look at a couple of those tribunal cases. I think they're probably two of the more recent ones, and that's the only reason that we've really chosen those particular two. But they do, I think, help us see a bit more about how the tribunals are approaching this area, and therefore hopefully helpful to you guys. The first one is Mrs. Linsky and Direct Line. And she was a telesales consultant for them between 2016 and 2022, and in 2019 started to suffer with menopause symptoms. She was put on what they described as a success plan, which is basically a performance improvement plan, and as part of that was issued with a written warning. Now, one of the things that they picked her up on was the fact that she was rude to customers on the telephone, that she was forgetful, and that her performance had been fantastic for the 3 years or 3 or 4 years that she had been working with them, but had dipped around this time. As part of that whole process, her mental health deteriorated. She was signed off sick from work, and they operated a discretionary sick pay scheme, and that sick pay was withdrawn. So they effectively said, we're not paying you your sick pay, even though the entitlement's there. We're exercising our discretion and not paying it to you. Towards the end of 2021, she raised a grievance alleging discrimination, and that wasn't upheld. So the employer didn't uphold, Direct Line didn't uphold that. And in May 22, she resigned, referring to a failure to make reasonable adjustments for her and alleging sex, age, and disability discrimination. So those three claims that I'd mentioned earlier. So for the purposes of the session today, we're going to primarily be focusing on the disability discrimination claim, and I think it's worth just reminding ourselves of what the legal definition of disability is, which is a physical or mental impairment that has a substantial and long-term adverse effect on the person's ability to do their day-to-day activities. I can usually reel that off, but I did write that one down for today. But the key is that it in particular for the cases we're looking at, that it's substantial and that it's long term and that it has a negative or adverse effect on the person's ability to do day-to-day activities. And that applies to any condition that anybody can be suffering with, and if it meets that definition, then the person and the tribunal decides that it meets that definition, that person will then receive disability discrimination protection. Whether they've actually then been discriminated against, of course, is a different thing, and the tribunal would go on to look at that, but they would be classed as disabled for the purposes of the legal definition in those circumstances. So it was interesting in this one. I think initially Direct Line appeared to have disputed disability in the case. So effectively said these menopause symptoms that she is experiencing don't meet the definition. But eventually they did concede, and they were criticised by the tribunal for this because it took so long for them to concede that actually she was disabled for the purposes of the Equality Act, and that the symptoms of low mood, anxiety, mood swings, effect on memory and poor concentration were sufficiently serious, did meet that definition that I just set out for you. They then went on to uphold her claims for discrimination arising from disability and the failure to make reasonable adjustments. What they didn't do was uphold her constructive dismissal claim or her age and sex discrimination claim, so they failed. In particular, I think the constructive dismissal claim appears to have failed because they found that she delayed resigning too long. So effectively, the legal test was that she'd affirmed the contract by continuing working and not resigning quickly enough in response to the breach that Direct Line had kind of had made. So that's partly why that failed. What they found on the disability discrimination side was that the poor performance review outcome, so the written warning and the fact that she was on that success plan at all, and the fact that it resulted in a lack of a pay rise as a result of that poor kind of appraisal grading, was something arising from the disability and therefore discriminatory, and that they'd also failed to make reasonable adjustments. And interestingly, what the tribunal said in this case was that they should have removed the performance plan altogether, that they should have referred her to occupational health earlier in the process, and that they should also have considered other roles that she might have been able to do. So quite scathing of the way that Direct Line handled it, and I think, you know, obviously it's just a first instance tribunal decision, but does give some guidance as to how the tribunals, you know, will approach these kind of issues. She was awarded, because people always like to know what the money awarded was. She was awarded £64,000. £23,000 of that was injury to feelings, so hurt feelings for the discrimination that she'd suffered. And interestingly, I mentioned that the employer were criticised for not conceding disability early in the process and agreeing that menopause was, you know, sufficient in this case to meet the definition. They actually awarded aggravated damages, which is quite unusual in the tribunal, of £2,500 for the fact that they took that quite robust line and said, you know, we don't believe that she is disabled or she meets that definition. So that's a case where obviously it went in favour of the employee, and it was found that menopause was a disability, did meet the definition. The second case, I've kind of given away the answer, but it might not surprise you to hear, is one where they found that the person wasn't disabled under the Equality Act. And in this case, Mrs. Davey was employed as a bus driver for quite a long time with this bus company. She brought claims, and we don't have a huge amount of detail on what the actual claims were, because this was essentially a hearing to decide whether she was disabled or not. But she brought a disability discrimination claim amongst a number of other claims. It did reference the fact that her menopause symptoms included fatigue. They described it as almost constant bleeding, difficulty sleeping, brain fog, and a number of other symptoms. And again, in this case, the respondent also disputed disability and said, look, we don't believe that the definition is met. Now, the tribunal went through, as they do in these cases, quite a detailed analysis of whether what the condition that the individual is suffering with is enough to meet the definition of disabled. And they actually found that it was an impairment. It was an impairment. It did have an impact on day-to-day activities. And it was interesting that although the claimant gave evidence that she managed to come to work and do her job, she gave very well-received evidence, I think, by the tribunal, as in they believed her, that actually she would then go home and would be unable to do much else. So wasn't able to do housework or cook or socialise or look after her grandchildren and that kind of thing. And I think that's probably quite a common situation where people are battling through the work day, but actually it is having an impact on them. But the evidence was that, and in fact what they found was that actually it didn't meet the definition from the perspective of it being long term. And that appeared to be that as a result of medical records, and again, that's part of the evidence that the tribunal looks at in these situations, as well as what the individual is telling them in terms of the impact that it has on their day-to-day activities. But that suggested that actually the most serious of the symptoms had only actually lasted between April and July 2021. And part of the definition for or the guidance around whether something is long term is that it's lasted for 12 months or is likely to last for 12 months or more. And on this occasion, the tribunal decided that as a result of the symptoms that they could see in the period of time that they were experienced for, that it didn't meet the definition on the basis that it wasn't long term. And I suspect there are plenty of people that might disagree with that analysis, but on this particular case, that's the decision that they came to, and as a result, on the disability discrimination claim, that would fail altogether because she didn't meet the initial definition, and therefore the claims would just fall away, and they wouldn't even get to look at the next stage as to whether she had actually been discriminated against on that basis. So hopefully that's helpful. I think the advice that we tend to be giving clients is that, of course, there is the possibility that menopause will be found to be a disability because it has been, and that there is protection. Therefore, that's separate from the debate as to whether that's the appropriate way that it should be protected in law, and we may see further developments in that area. But essentially, the advice tends to involve us saying, look, you need to understand what the person is experiencing, what impact that's having on their work and their day-to-day activities. Medical advice is nearly always invaluable if you can get good medical advice, and we do a different session on managing that kind of process, because it's not always easy with occupational health providers to get good advice, but there are ways of doing that. And then considering adjustments, because it might be that the person is protected under the Equality Act, or just because actually adjustments are the right thing to do to try and ensure that the person remains in work and is performing as they should be, as with any situation like that. So that tends to be the approach that we would suggest in that area. So moving on, I think, to our final topic. And again, this is a pretty recent one, recently announced, a consultation on the reintroduction of employment tribunal fees. Now, those of you that have been around long enough, like James and I, will remember that back in 2013, where's the time go? The government actually introduced tribunal fees, and there was quite a lot of noise about it at the time, but it was in place for a number of years, and the fees were actually quite considerable. I think up to £1,200, to bring a claim, and there was therefore, as a result, a massive reduction in the number of tribunal claims being brought against employers because of the cost. And of course, if you've just resigned and left your job and you're out of work, or you've been dismissed, there's a fair chance that you weren't going to shell out that amount of money to bring a claim against your employer, hence the reduction in claims. Those fees were then removed on the basis that they were found to be unlawful, essentially, by the Supreme Court. And again, those of you remember, the fees were then all refunded to people, which was quite a task in itself. However, the issue has come back again, and there is a proposal from the government to reintroduce fees, but this time the fee of £55 for all tribunal claims, and a similar amount for employment appeals and that kind of thing. The thinking behind it, according to the government, is that a fee at that level is proportionate and generally affordable, and there are some estimates that it would raise between 1.3 and 1.7 per year to help fund the tribunal system. Now, there's no denying that the tribunal system is underfunded. Anybody who's doing any kind of tribunal work or has a tribunal claim against them as the employer at the minute will know that, to be frank, it's a complete mess. It's taking a very, very long time for claims to progress through the tribunal. 18 months, 2 years is really not unusual at all. They appear to be under-resourced when it comes to judges. They appear to be under-resourced when it comes to administrative staff to do things like type judgments and to reply to emails and that kind of thing. So there's no doubt that more funding would be helpful. But I think if you look at the actual cost of running that system, it's way, 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 way more than 1.7 million per year, and that's essentially a drop in the ocean, I think, in terms of the funding. So in my opinion, probably won't make a huge amount of difference on that front. It might well encourage some people to resolve disputes a bit earlier, but my guess is that it's more likely to result in a reduction in money claims against employers where employees are due smaller amounts of money, and that actually, if, I don't know, it's a week's notice pay that an employer hasn't paid, that's due to somebody, and that's, I don't know, £250, paying £55 in the hope that you might recover your week's pay, probably won't be proportionate, and that effectively it will put people off making those kind of claims. Whereas if you think, well, I've been unfairly dismissed, or I've been dismissed because I've blown the whistle, or that kind of thing, and there's potentially more money in it in that situation, the £55 might be worth investing, in the hope that you make that money back and recover some compensation. So unfortunately, it feels a bit like the people who probably would benefit from that small amount of money back, where employers haven't really done the right thing, might be put off recovering that, unfortunately. So we'll see how that goes. Consultation is open now and closes soon. Whether it will be introduced or not, we don't know. Whether there'll be a change of government in any event, we don't know either, but we'll see. So that takes us to the question section. There's obviously been a few of those in the chat. Do check those out if you haven't been as we go along. Some good questions, and we've done our best to reply to those as we go. Does anybody have anything else they'd like to ask as we have a few more minutes? There's usually a bit of silence and then somebody jumps in, but we're also happy that if nobody has a question. Okay, just to finish then, if you do have a question, then either pop it in the chat or let us know. I'm happy to be interrupted. As I said at the start, in case people hadn't logged in at that point, we are running a free employment contract review at the minute. We're seeing a lot of non-compliant contracts still, in terms of them being missing some stuff that needs to be in there. So we're happy to have a look at that for you. We're running lots of training, we're running lots of webinars, but we're also running lots of bespoke training for clients at the minute. And if that would be of interest, do let us know. I think there's probably a link to the East Midlands HR network in the chat. If there isn't, I'm sure Matt will pop that there. And if you're local to us, we'd love to see you at one of our events. I also talked about the podcast, and we'd love it if you could check that out and let us have any feedback. And also, in case you haven't had enough professional development or enough of me talking at you, I've also speaking at a webinar. Very pleased, I think Amy from Astute Recruitment's actually on the call today, but next Thursday, 7th of March, I'm covering some other updates on various bits and pieces as well. So if the topics there are of interest, it would be great to see you there. I think we've got 100 people signed up already for that one, so really excited about that. And I think Matt's going to pop a link to that in the chat as well. So yeah, unless there are any last minute questions, thanks so much for joining us. Hopefully there's been something useful in there. And yeah, as I say, if you're grappling with any of it, particularly the holiday pay, James would love to hear from you. But yeah, thanks everybody, and we'll catch you soon.
Thanks.